Honorable Chief Justice Jason Kausa, Honorable Chief Justice Lord Felipe Zulu, Honorable Chief Justice Desmond Carter presiding.
If you may please be seated, Honorable Court, I seek to call the case. The facts of the case. Juma Choma Choma, a 19-year-old pupil at St. Joseph High School, is a boyfriend of Kachingwe Kalando, a 14-year-old girl. She is in grade 7 at the same school as her boyfriend. Juma pleads with his parents to allow him to get married to Kachingwe before he sits for his grade 12 examinations. However, his parents are not convinced about the ascending to his request. Later, the parents decide to consult some of their relatives who seem inclined to the idea of Juma. On the basis of the consultation, a delegate is sent to convey the request of Juma's parents to Kachingwe's parents. The parents of Kachingwe agree to the suggestion, and a date is set for the conduct of the traditional ritual of marriage. A month later, the African customary rites are performed at both places of the residence of the would-be spouses, thereby signifying a truly African customary marriages celebration. After 2 days following the consummation of the tradition of the customary marriage, the matter is reported to the police by a local non-governmental organization on the basis that it violates the Penal Code, Chapter 87 of the laws of Zambia. The NGO also argues that such a marriage is contrary to the public policy as pronounced from the time by the Ministry of Gender Development. As such, both the parents of the spouses as well as the spouses themselves should be persecuted. The police act on these allegations, and the parents of the partners to the marriage, including Juma, are subsequently arrested. At the trial in the subordinate court, the charges against the parents of the partners were withdrawn by the police for technical and procedural reasons. Juma, however, was charged with defilement of sumo, contrary to Section 138(1) of the Penal Code, Chapter 87, as amended by Act Number 15 of 2005, Laws of Zambia. The senior magistrate hearing the matter convicts Juma of defilement under Section 138(1) and commits him to the High Court for sentencing at the end of the long trial. The High Court sentences Juma to 15 years imprisonment with hard labor. Juma is very disappointed with the sentence and the whole trial as well. He feels that it was his basic or fundamental human right under the Zambian Constitution to marry anyone he pleases, and as such was simply exercising his right. Momo wants to appeal to the Supreme Court against the conviction of the court. The court is now in session.
My name is Christopher Cavendish. I'm appearing together with co-counsel Mukemwa. My number is 084033. Co-counsel's my number is 085372. May it please honorable court, before counsel proceeds, counsel seeks leave to draw the court's attention to the fourth page in our brief, starting from the first paragraph 1.0, the first line, where it states "my lords and my lady." Counsel seeks to strike out "my lady," as there is no lady justice on the bench. That applies to everywhere in the brief where it states "my lords and my lady," and it states "my lords." Most of the time. My lords, we are appearing on behalf of the appellants and so, we have raised two grounds of appeal. Core counsel will rise and argue the first ground of appeal, and I will then rise and argue the second ground of appeal, from whence we've advanced three arguments. Subsequently, I will move to the prayer. Unless counsel may be of any further assistance to the courts, I seek leave to call on my co-counsel to argue the first round of appeal.
May it please this honorable court, as stated by my lead counsel, my name is Interclass, man number 085372.
Can you repeat the number again?
085372. Much obliged, my lord. I seek leave to address the issue of jurisdiction. Much obliged, my lord. We make reference to the Court of Appeal Act of 2016. I therefore beg you to make quotation. Much obliged. Section 14, subsection 3 states, as I read, a person convicted by a subordinate court and committed to the High Court for sentence shall, upon being sentenced by the High Court for all purposes connected with that person's right of and procedural matters relating to the appeal, be considered to have been convicted and sentenced on trial by the High Court, and accordingly, an appeal against such conviction and sentence shall lie with the court. End of quotation. We just wish to draw the attention of this court that we are actually in the right court, which is the Court of Appeal.
What is jurisdiction?
Much obliged, my lord. Jurisdiction is the authority or power that a court has to hear certain matters.
Based on what?
Based on the Constitution.
The Constitution defines the jurisdiction. Does the Constitution define the jurisdiction? Is it counsel's aim to misguide and mislead the honorable?
Much obliged, my lord. That would not be my intention. The intention, however, is just to draw to this honorable court that we are actually appearing before the Court of Appeal based on the quotation that I have just read. The lower court judge failed to take into consideration what constitutes a valid customary marriage, and subsequently failed to appreciate that the appellant was rightfully married under the provisions of customary law. My lord, we are saying that the appellant has a right to be married, as we make, as this can be seen with the UDHR Article 16, which provides that any person, regardless of nationality, race, or religion, has the right, if they are of age, they can get married, they should have the right to marry and found a family.
You're citing the international document. That article stated that the Universal Declaration of Human Rights applicable to Zambian citizens.
Much obliged, my lord. We do concede that the article which was just quoted is not binding on the Zambian society. However, it should be noted that we are just using it as a roadmap to highlight how how rights how the rights and freedoms of people that are of nations that are member states to the United Nations, how they are to enact their laws and also enforce them. Therefore, based on that, the UDHR sets a universal standard of how these rights and freedoms are to be enforced. As we all know that our very Bill of Rights is, we could say, it's it gets, the blueprint is the UDHR from which we draw our own Bill of Rights. It is formed after the UDHR.
Does the Zambian Bill of Rights contain any rights relating to marriage?
Much obliged, my lord. Whilst the Zambian Bill of Rights doesn't explicitly contain any such provision as the right to marry, it could be, however, be wise to consider that our very own High Court has a division known as the Family Division of the High Court, which means that, at least impliedly, our very own law does recognize that we have families which are, as a subsequent result of two people getting married.
In the question. Question is, do our laws under the Bill of Rights, but we of the Zambian Constitution contain rights in relation to what you just cited in the UDHR? Are there rights that are exactly extracted from the UDHR that are in relation to what you cite in our Bill of Rights?
Much obliged, my lord.
It's a yes or no answer. Just that.
They do not.
They do not, right?
Much obliged, my lord.
Are you familiar with the case of Zambia Sugar PLC versus Appellant?
Much obliged, my lord. Council has not directed this matter.
Are you familiar with the case of Roy Clark versus Appellant?
Much obliged, my lord.
So then you are aware that Zambia is a dualistic state. That means that whenever we ratify an international instrument, it must first be domesticated for it to have legal force here in Zambia.
Much obliged, my lord.
So then, would it be correct if this honorable court was to strike off or not take into record the consideration of the citation of the Universal Declaration, particularly this article, because you have not provided any law under our jurisdiction that has domesticated the article that you have cited relating to the right to marriage?
Much obliged, my lord. The cited article is merely there for persuasive reasons.
But it is a law. How do you persuade us with a law that is not enforced in Zambia? The whole essence of having a dualistic system is that we should have some own laws that domesticate international interests. So, as I've guided you to the case of Zambia Sugar versus Appellant, you will note that in that case, it was held that if the instrument has not been domesticated, it has no legal force in Zambia.
Much obliged, my lord. We are aware that Zambia accedes to the United Nations. Therefore, on basis of that, we do recognize the Universal Declaration of Human Rights. And under that
Before you
declaration,
confuse the court, the Universal Declaration of Human Rights and the United Nations Charter are two distinct instruments under international law. And they are two distinct instruments, not only in their very nature, but in the effect that they have. A declaration is a standard. It's not binding. We're bound by the UN Charter, yes. Zambia is bound by that charter. But nowhere in the charter is it stated that the UDHR abides it. So now you're trying to defend the question. Proceed with your argument.
Much obliged, my lord. I seek leave to draw the attention of the court to Zambia's response to the Convention on the Elimination of All Forms of Discrimination Against Women on page 41.
Again, is the CEDAW domesticated in Zambia? The Convention on the Elimination of All Forms of Discrimination Against Women, is that convention domesticated in Zambia?
Much obliged, my lord. I'm making reference to the response that Zambia gave to that convention, not quoting what that convention states.
What essence is that reference?
As it will help to highlight the argument which we are trying to put across to this one. Much obliged. The Zambian government stated that there is no minimum age of consent to marry for women under customary law, so long as the girl has reached puberty. That being stated, we are trying to also say that it is our contention that the appellant's marriage to his wife was valid and legally binding, albeit it was contracted under customary law, because customary law is recognized and therefore binding customary law as binding, as this is provided for under Article 7 and Article 7 Clause D of the laws of Zambia. Therefore, being that this was an official statement by the government, it is therefore binding on the Zambian peoples.
Council, are you stating that the statement made by government official comes for a design?
Much obliged, Lord. So long as that statement is enshrined in law, then yes, it is binding.
In the issue at hand, is that statement enshrined in the
Much obliged, Lord. Considering that the requirements for customary law just require consent from the parents as well as dowry, and that customary law is protected under the Constitution itself, and this response that was given in response to customary laws that we have in Zambia. Therefore, we would say that that statement is binding. I simply proceed with my argument. Furthermore, my lords, Article 7, Clause D of the Constitution of Zambia, Act number 2 of 2016, recognizes the practices of customary law as stated earlier. Therefore, this subsequently gives recognition to marriages that are contracted under customary law. And as if further to show the significance of customary law in Zambia, we have the landmark case of Chibwe versus Chibwe, where it was stated, allow me, I simply to cite the quotation. Much obliged. Zambian courts must invoke both the principles of equity and law concurrently. The court further stated that customary law in Zambia is recognized by the Constitution. Its application, so long as its application is not repugnant to any written law. End of quote. My lords, the authorities cited above are fundamental as they go to the core of our case that we're arguing here today. This is because failure by the courts to recognize marriages that subsisted between the appellant and his wife amounted to a breach in the appellant's right to contract such a marriage, such a union.
You rightly directed this honorable court to the case of Chibwe versus Chibwe, and let me quote the last one. Customary law in Zambia is recognized by the Constitution provided that its application is not repugnant to any written law. Under a minute, address us in regards to these aspects that you cited and in relation to Section 18 of the Children's Code Act, which provides for the protection against child marriages for all children. Just under a minute.
Well,
how do you reconcile that? Isn't that a violation of written law?
as we are aware that the Constitution is the supreme law, and therefore all laws must be in line with its provisions, and any provision that goes against it is null and void to that extent. However, we also know that the same Constitution also provides for the protection and recognition of customary practices, or customary law as a whole. And customary marriage falls under, so it's governed by customary law.
To what extent does the Constitution allow the upholding of customary law as its right to praise it? To what extent?
The point as stated by the Constitution, if it's a
Provided that it is not
repugnant to the provisions of the Constitution.
Okay. The provisions of the Constitution or any other written law. Finish that. Any other written law. Exactly. The Children's Code is saying child marriages are prohibited. and they've rightly used the word prohibited to show that there's a ban there. So any practice that is allowing such, is it contradicting the written law?
Much obliged, my lord. That would be the case. However, allow me to draw the court's attention to section 38 of the Marriage Act, which actually does recognize customary marriages. It provides for statutory marriages. However, it also does recognize any marriage contracted under customary law as a validly binding marriage.
So regardless as to whether that marriage violates any written law, it is repugnant to natural justice, provided that it's contracted under customary law, it's right.
Much obliged, my lord. As stated earlier, customary law is protected under the Constitution. Further, as if to further our argument, the Marriage Act itself does also show that marriages contracted under customary law are recognized, so long as the requirements for that marriage are met, which is of course consent from the parents, which if we read the record of proceedings, we show that there was consent from both the male and the female part. Their parents or guardians consented to the marriage. Therefore, on that basis alone, we would say this was a valid marriage.
Also, we do not, it's not in contention that Zambia does apply or consider customary law as one of the laws that are supposed to be applied in the jurisdiction. That is not in contention. What is in contention here is a repugnancy of customary practice. So I will ask you directly, if you have a daughter who is 14 years old, would you give enough to marry?
Am I to answer that question on the basis of law or feelings? Because
Just yes or no, whichever you feel like you want to answer. Law or feelings, would you give your own daughter who is 14 years old of to marry?
much obliged, my lord. We all know that the rule of law states that we are all under the law. Therefore, as if something is provided for under the law, we are to abide by such provisions, albeit that customary law is not codified rather. Therefore, on that basis, I would say yes.
You will give your daughter who is 14 years old.
Much obliged.
Sorry. Okay. That is may conclude your argument, counsel.
Much obliged, my lord. My lords, it is therefore we submit to this court that the lower court erred when they upheld the conviction of the appellant because he was rightfully married to his partner. I seek leave to rest. Much obliged.
May please, Honorable Court, counsel seeks leave to proceed during the second round of the plea. Most obliged. My lords, it is our contention that the lower court erred in fact and in law when it found the appellant guilty of the offense of defilement as provided by the Penal Code section 1381, and subsequently committed him to the High Court for sentencing, where he was sentenced to 15 years imprisonment at level. My lords, this was a serious misdirection on the point of law by the lower courts. Also, a serious misdirection on the interpretation of laws dealing with customary laws, particularly when it comes to customary marriages in Zambia. My lords.
You're stating that it's a misdirection. I note that from your brief as well. That sentence comes immediately after the sentence of 15 years imprisonment. And you call that a misdirection on the point of how is it a misdirection? What is the maximum sentence for that?
Most obliged. My lords, the context which we used with regards to misdirection was simply referring to the misdirection that the court refers to how the court misdirected itself by convicting the appellant, neglecting the fact that the appellant was marriage under customary law. That is the misdirection on a point of law.
Okay.
Most obliged. My lords, it is strike law that where a customary marriage is validly contracted, the consummation of that marriage shall not, and at no means, shall it constitute having unlawful carnal knowledge of a girl under the age of 16 years, as provided by the penal code. My lord, the main, the statement of putting emphasis on in this particular matter is having unlawful carnal knowledge. My lords, in order to argue this ground, we have advanced three arguments. We first address the issue of Zambia being a dual legal system, and the plea of court counsel seeks to proceed in this substance. Most obliged. My lords and my ladies, apologies, my lords, it is a notorious fact that Zambia adopted a dual legal system of administration upon becoming a sovereign state. This means that both customary law and statutory law shall apply in the administration of justice in Zambia. We find solace in the constitutional provision of Article 7D of the Constitution. My lords, not only that, the learned author on legal process, Zambian cases, materials, and commentaries at page 52 observes that Zambia has a dual legal system made up of general or statutory law and the tribe-specific customary laws. The importance of that in relation to rape. Most obliged. Counsel has made his mind to start.
Okay, let's go to the Parliament. What law applies?
What apply?
And what is your justification for that?
Most
Customary
obliged.
law applies to development?
Most obliged, ma'am. With regards to defilement, it can only be unlawful carnal knowledge if you are not legally married to the person, that is the girl. However, Zambia being a dual legal system recognizes both customary law and statutory law. And under customary law, you have customary marriages. And it is trite law that where one is has contracted marriage under customary law, the consummation of that marriage shall not amount to unlawful carnal knowledge of the girl, because the marriage is recognized and is valid. In short, you cannot defile your wife. It's impossible.
What is lawful carnal knowledge?
Lawful carnal knowledge is having carnal knowledge within the confines of the law.
What is the confines of the law in this regard?
As is provided by the penal code, lawful carnal knowledge is the confines of the law
Is
is
trying to really just misdirect us. Where in the penal code is it provided that lawful carnal knowledge exists?
most obliged, my lord. As counsel was not of the intention to misdirect the courts. However, in addressing the issue of lawful carnal knowledge and the confines of the law, we simply refer to most of there is no law that defines lawful carnal knowledge, to the best of my knowledge.
Is this quite limited to your knowledge?
Most of
Are we limited to this to your knowledge?
Yes.
What's up, first?
most of that, following interpretation, lawful carnal knowledge would be looking at defilement is applies to girls below the age of 16, and that means if you are having carnal knowledge of a girl above the age of 16 and you're legally married, then that is lawful carnal knowledge.
Does the penal code talk about marriage?
No,
Under that provision, it doesn't, right?
no, ma'am.
What does it refer to? The age, right?
Age.
So, in relation to that provision, local carnal knowledge will be having sexual intercourse with the girl who's above the age of 16, right?
Most of that.
Is that the case in this case?
Most of that. This case is distinguished from from that provision because this case is in relation to customary marriage. That having stated that, under customary marriages, there is no legal age. There is no age as prescribed to which a girl can be married, provided the girl has reached the age of puberty. The girl is fruitful enough to get into marriage, to be married.
So how do you determine the age of puberty?
Most of that, there is really no specific age with regards to puberty, because others start at an even earlier age. Other females would start their puberty stages as early as 12. So there is no specific age with regards to puberty. But as long as, under customary law, as long as the girl or the boy has reached the age of puberty, he is of age to marry under customary law.
So according to the facts of the case, the facts state that the girl has reached puberty. That's your quotation?
Most obliged, my lord. A girl of 14 years old is expected to have obtained puberty.
Now you contradicted yourself. Because you were saying it is subjective. They can start their puberty at any age. That was your earlier statement. And here you are saying it is presumed that when you're 14, you have already reached puberty.
Most obliged. My lords, according to the facts, it doesn't state whether the girl was at puberty or was not. And so the courts ought to have taken further steps to identify whether or not the girl had reached the age of puberty or not.
The only job that the court needed to do was to assess as to whether your client was guilty of defilement. And the test for defilement is clear under section 138. Having canon knowledge of the girl was below the age of 16, which is exactly in the first place.
Most obliged. However, the girl was married under customary laws. The girl was married, and under customary laws, it was a valid marriage because making reference to the case of Sivande and the people, where it was stated and constituted to court, if there is evidence fit to be left to a jury that the parties were married according to customary laws, the onus would be on the prosecution to negative that suggestion. But it is not enough for an accused to simply say we are married, or even we are married according to customary law. You must at least say we are married according to customary law because we did this and this. And it would be then for the prosecution to show that events alleged, assuming they were accepted, did not constitute a valid marriage according to customary law. My lords, referring this court to paragraph 2 of the record of proceedings, it is provided under paragraph 2 of the record of proceedings that the parties underwent the rights and traditions that would amount to constitute a valid customary marriage. Meaning, the parties were legally married under customary laws. And Zambia, being a dual legal system, observes that customary marriages are valid and legal. That is provided for also under section 34 of the Marriage Act. Meaning that customary marriages are considered and are respected. Therefore, one cannot, addressing the issue of defilement now, one cannot defile someone he is legally married to. Hence,
a similar question was posed to your learned brother, that it is not in contention that Zambia does apply customary marriage. And it is not in contention that courts in Zambia uphold customary marriages. What we're looking at here is a repugnancy of a practice that is a contention in this question, in this case at hand. So I'll ask you a question. How old was the girl who was involved in this case?
most of life, the girl was 14 years old.
Would you say that girl is a child?
Most of life.
Do you have children's code?
Most of life.
Can you go to section 18?
Section 18?
Yes.
And then,
Code section 18.
most of life. 18. 1. A person shall not subject a girl child to female genital mutilation. 2. A person shall not subject a child to A. Child marriage, or B. Cultural rights and religious or traditional practices that are likely to negatively affect the child's life, health, social welfare, dignity, and physical or psychological development.
Just the
Most of life.
So, in that section, you've noted that a person shall not subject a girl child to child marriage, and you've noted, you've accepted that this was a child. So you want this court to uphold a child marriage.
Most of life, my lord. There is a reason why we have dual legal system. That is to preserve our culture, our norms, and our beliefs. The reason why this case is distinct from the provision of section 18 is the fact that under the culture that which this girl was contracted at, it refers to, it has no provision for child marriages. In fact, under the culture is supreme.
So if statutory law is supreme, and it's saying that child marriages are not permitted, they are not allowed in our jurisdiction, why do you want us to uphold that which is under customary law? And in this case, it is inconsistent with written law.
Most obliged, my lord. If my lord may ask the question again.
I asked you a question, so which one is supreme between customary law and statutory law? And your response is statutory law is supreme to customary law. So if statutory law is telling us that a person shall not subject a child to child marriages, which under customary law is okay, why do you want this court to uphold which is under customary, not follow statutory law, which is supreme?
Most obliged, my lord. I seek leave to consult. Most obliged, my lord. In response to his lordship's question, the statute that regulates marriages in the country, that is the Marriage Act, that provided for under section 34, it states that there is recognition of both customary laws and customary marriages and statutory marriages. So
Yes,
by that nature,
we get that. We do not dispute it. Customary marriages are accepted in Zambia. We get that. It is actually recognized under the Marriages Act. We get that. But also you have to note that the Children's Court is meant to protect the rights of children. So here, what we're not disputing that a marriage act, which is validly acquired under customary laws, would be valid. We would not dispute that. But what we're disputing is the person that is involved. A child is involved in this matter. A child is involved. And we have a separate legislation that is speaking to children not being given away into marriage.
disputes that is consistent with the provisions of the Constitution.
Okay. Go to Article 7D, the one you cited in the brief.
Article 7D. Most obliged. Zambian customary law, which is consistent with this Constitution.
That's what it says.
Article 7 itself says the laws of Zambia consist of going to D, Zambian customary law, which is consistent with this Constitution.
Okay. So now, you disputing that the Children's Court is consistent with the Constitution. But according to the case of Thomas Mumba versus the people, it was decided in that case that any act of parliament that is ever enacted is presumed to be in conformity with the Constitution until such act of parliament is challenged. So there being no challenge that has come that the Children's Court is inconsistent with the Constitution of Zambia, simply says that we presume the Children's Court is actually consistent with the Constitution. And from your citation, you stated that if a customary practice is consistent with the Constitution or any other written law, then that customary practice will be upheld. But if it is inconsistent, and here we have it, this customary practice which allows anyone who is reached the age of puberty, regardless of their age, into marriage. And then we have a written law which is saying that a child who is taken into marriage, a person who takes that child into marriage commits an offense. If you go back to section 18, you find that commits an offense. So what you are simply trying to do is make this court uphold an injustice, uphold a criminality. Is that really your submission? Now, I pose the question to your learned brother. If your child was 14 years old, would you give your child off into marriage?
Most obliged, my lord. Provided it is under customary laws, of course.
Okay.
Most obliged.
Before you proceed, your friend, I'd like to ask something. Are you familiar with the concept of void marriage?
Most obliged.
Can you elaborate on that?
Void marriage is most obliged. Void marriage, according to Lilian Shota, when we family law, she observed that the void marriage is one that is invalid right from the beginning.
Now here we're seeing that the children's court has much emphasis on the rights of marriage. And we're seeing that it's inconsistent with customary laws. what do you think is the effect of the Deport for the Bill on the state of customary marriage when it comes to early marriage?
Most of likely, I'll address the Children's Code as one which regulates, of course, the rights of the child. However, we still uphold the fact that we have customary practices which have been in existence since time immemorial. And these are practices that have been practiced by, that have been practiced and are still being practiced. By that very nature, it means by virtue of Zambia being a dual legal system, we have to uphold the practices of customary law. Otherwise, we lose our culture, we lose our norms, and we lose our beliefs. By that very nature, it means we are simply adopting a practice that is imposed on us by our colonizers.
Very proceed, you're sharing very strong statements when it comes to customary law. I appreciate that our law is supposed to reflect our views as society and should be understood in our context. So, is it your position that if a custom was to result in an injustice, the court is bound to uphold that custom based on the sole fact that it's part of our identity as a nation?
Most of
Before you
life,
respond to that, did we lose our identity when we overruled the Appellant custom in Cavendish? Just answer the questions.
most of life, my lord. If my lord would repeat the question on Moot.
You said us negating to observe customary laws, us doing away with our practices and losing our identity and adopting foreign policies. My question to you is, did we lose our identity when we did away with the Appellant custom in the Kaniki versus Jairus case?
Most of life, my lord. Counsel has not addressed his mind to the Moot and Jairus case. However, I will address his lordship question, noting the fact that we, by virtue of us having adopted customary law and statutory law, it means that we uphold both customary laws, customary practices, and statutory law. Therefore, if we are to, as the justice in the case of Zambia and the people stated, it provides that we are to administer both customary laws and statutory laws in the administration of justice. And therefore, it means customary practices are binding on the courts, same as statutory laws. We are using a dual legal system. We did not lose, by virtue of us then now simply relying on statutory laws to do away with our customs, it means we are losing our identity as a state. It means we have to change now and start using statutory laws anyway, because if we cannot uphold our very own customs, our very own norms and beliefs, then why in the first place did we adopt both customary laws and statutory laws to administer justice in our state? We adopted those two because we recognize the importance of the existence of customary laws, and also recognize that we need some civilization with regards to statutory laws.
Counsel, proceed to your prayer. I think to this point that you are going in circles on the same issue.
Most obliged. My lords and my ladies, most obliged, my lords, may that be stated for record.
Immediately his lordship is wearing his cape. You identify as she?
Most obliged, my lord. My lords, it is therefore our submission that the lower court erred in fact and in law when it found that the appellant and the Kachingwe Kalando, who is the girl in this case, were not lawfully married because they had convicted the appellant of defilement. This is because under customary law, a man has the right to marry any girl, woman, or lady provided he has reached the age of puberty. The right has been preserved by various customs and norms in Zambia, and they are to be protected and respected by the judicial system of this country, because we recognize both customary laws and statutory laws as we have raised in the first argument of the second round of appeal. We therefore submit that the lower court erred in law, and in fact we found the appellant guilty of defilement, when in fact the appellant was legally married under customary laws, and therefore one cannot have unlawful canon knowledge of a girl under the age of 16 if he is legally married to that girl. With that regard, it is on this ground that the appellant prays that this honorable court finds merit in the two grounds of appeal and reverses the lower court's decision, thereby quashing the appellant's conviction. Counsel seeks leave to rest. Most obliged.
If you may please, this honorable court, my name is Appellant, counsel for the respondent, practicing license 072337. And my fellow colleague name is Benjamin.
Your practicing license again?
072337. And my co-counsel is Benjamin Koma. His practicing license is 057316. If you may please this honorable court, I seek leave to proceed.
Proceed, counsel.
Much obliged, my lord. My lord, to begin with, the appellants have raised a ground of appeal stipulating, or rather putting their reliance on the Universal Declaration of Human Rights, particularly Article 16. With that being said, my lord, I believe that for this particular international instrument to be used in Zambia, it must be domesticated. My lord, this was actually stipulated in the case of Roy Clark versus the Attorney General, in which it was stipulated that before an international instrument can be applied in our court system in the Zambian jurisdiction, it must be domesticated. It is for this reason that we ask that this honorable court should dismiss this ground of appeal, because this international instrument has not been domesticated in our Zambian jurisdiction.
Counsel, in the case of George Peter Mans and another versus Attorney General, the court noted that there's a huge trend of directly applying international law. This is based on the fact that states ratify these international treaties and imposing on themselves an obligation to enforce them. Because, as you know, at international law, the states have this responsibility. So, when we think in this regard, this court needs to give consideration to this particular treaty, the respondent has said,
Much obliged, my lord.
the appellant has said.
Much obliged, my lord. As I have already stipulated that, I seek leave from the court, as I have already stipulated that in the case of Roy Clark versus the Attorney General, it was demonstrated that for you to be able to apply any international instrument, it must be domesticated. Furthermore, my lord, I would like to bring to the attention of the court to section 63, subsection 1 of the Constitution that clearly guides us on how the international instruments should be applied in our Zambian legal system, meaning that they should pass through legislation through the parliament for them to be able to give an effect into our court system of Zambia. I seek leave to proceed.
Before you proceed, counsel, we take cognizance of the decision in the Roy Clark case. But His Lordship has directed you to a more recent case, the Mwanza and Benny versus the Attorney General case, where this honorable court stated that we ought to follow the trend of applying international law directly and requiring it to be domesticated first. Because at the end of the day, this international law binds the country as a whole on the international level. You have not addressed us on that issue. You only stated what you said in the Roy Clark case.
Much obliged, my lord. Despite there being such type of a recent law, my lord, I still stand on the ground that before any international instrument is applied in Zambia, it should be domesticated. As I have already stated, even the Constitution under Section 63, subsection 1, clearly stipulates that these particular international instruments should be domesticated in our country. They should pass through the parliament. The president must actually assent to it before they can actually have an effect in our Zambian legal system.
Proceed, counsel.
Much obliged, my lord. Furthermore, my lord, the other thing that the appellants are talking about, they drive the attention of the court to the fact that Zambia is a dual legal system. My Lord, we do recognize that the fact that indeed Zambia is a dual legal system. However, that means that we apply both customary law and written laws or statutory law. But my Lord, before those particular customary laws can be applied into the Zambian jurisdiction, they must meet some certain type of conditions. My Lord, it is for this reason that even the Constitution itself, under Article 1, it clearly states that the Constitution is the supreme law of the land, and any other law that is inconsistent with it should be considered null and void. It is for this reason that despite the Zambian legal system allowing the implementation of the customary law system, it should be consistent with what the written laws are saying. In this particular case, having a girl child who is 14 years old, marrying her off at that particular age is consistent to our Zambian constitution, in a sense that this is a child. This is stipulated under Article 266 of the Constitution. I seek link from the court to court from the Constitution. Much obliged, my Lord. Under Article 266 of the Constitution of Zambia, it defines a child as, a child means a person who has attained or is below the age of 18 years old. And it further defines an adult as a person who is above the age of 19 years old. It is for this reason that we are saying that the person that they married off is a child, and hence was not supposed to be married off. Furthermore, my Lord and my Lord, in the case of Kaniki versus Giles, it established conditions under which customary law can be applicable in our Zambian jurisdiction. And it clearly stipulated that for any customary law to be applicable in Zambia, it should be consistent with what the Constitution is clearly saying. And if it is repugnant to what the Constitution is saying, then that particular law should not be considered. My Lord?
Are we bound by that decision?
Yes, my Lord.
Okay, justify us why we're bound by a High Court decision when we are superior.
My Lord, we are bound by this statement that stipulates that customary law can only be applied if it is not repugnant to the Zambian Constitution. Because, my Lord, if we look into the same Constitution that we have, that is the supreme law of our land, it clearly stipulates that if it is repugnant to our Zambian Constitution, it cannot be applied. So, in as much as this case is also I'm just giving this case in order to marry it to what the Constitution is actually stipulating, my Lord.
Counsel,
Much of that.
you've made very good submissions on repugnance, but you keep making reference to repugnance to the Constitution. And in your oral submissions, I've only heard you make reference to Article 266, outlining the age for a marriage.
Yeah.
Now, in relation to the issue at hand, when it comes to marriage, which constitutional provision are you saying is being contravened in this regard?
Much obliged, my Lord. The reason why I am mentioning the Constitution in this instance, I'm talking about their ground of appeal that the Appellant has given us. The Appellants are stipulating that in Zambia we apply both customary and written laws. And us as the respondents, we are saying that indeed we agree to that statement. We apply both customary and written laws. However, our Constitution is telling us that before such kind of customary laws or international laws are applied in this particular jurisdiction, they must not be repugnant to our own Zambian Constitution. And I want further...
Before you proceed, Counsel, those arguments, you've heard them, don't repeat them.
Much obliged.
Now my question is, which provision of the Constitution is in contention?
Which provision of the?
The Constitution. You are saying customary law should not be repugnant to the Constitution. Now, which provision of the Constitution are you going to rely on?
Okay. Much obliged, my Lord. I'm relying on the fact that the person that was married off is a child.
Counsel,
And furthermore,
counsel, before you proceed, we don't want the facts. That's the provision, article.
okay, much obliged, my lord. I would like to draw the attention of the court to the section 18 of the Children's Court Act, which clearly stipulates that a child below the age of 18 should not be subjected to such kind of early marriages.
Counsel, you're relying on Kennedy versus Vera, okay?
Yes, to bring about the conditions that should be met before applying customary law.
Yes. I think your submission, let me say, repugnant to the Constitution.
Much obliged.
Yes, so which article is the customary marriage being repugnant to?
Which article is the? It's the article that the customary law marriage is being repugnant to is that of section 18 of the Children's Act of the Children's Code, Article 18 of the Children's Code Act.
Article 18, relax. The question is, you are saying the practice, if the facts of the case, is repugnant to the Constitution. What provision in the Constitution is that practice in the fact repugnant to?
My lord, I seek you to consult.
Is
Much obliged. My lord, I've just been guided that it's Article 7, subsection D of the Constitution.
And what does it provide?
I seek leave to quote from the Constitution.
Court counsel.
The laws of Zambia consist of this constitution, B, laws enacted by parliament, C, statutory instruments, Zambia customary law, which is consistent with this constitution, and the laws and the statute which apply or extend to Zambia as prescribed.
Yes, counsel. Now, my one initial question, which article are you going to say is going to point to an inconsistency with customary law when it comes to marriage? Because you've only spoken of the age.
Okay. My lord, to answer that question, I was only trying, I quoted the constitution because the constitution itself brings up the aspect that that any other laws, be it customary law, should be consistent with it. And in this particular case, my lord, it's a child that's being married off. It's a child whose rights can be deprived. Because when we look at the Children's Code Act, my lord, it clearly gives us the list of rights that every child has. And for this reason, if a child is being married off at that particular age, it means that their rights will be taken off from them. And so this is going against our own written laws, because even the Constitution itself, the Penal Code itself, under Section 138, it stipulates that if you have carnal knowledge, put the girl who is below the age of 16 years, and that can be considered as defilement. It is for this reason that we are saying that a child below the age of 16 should not be married off, because it is against our written laws. Where written laws and customary laws are in conflict, the written laws always prevails, my lord. It is for this reason that we are stating, even the current laws that we have, that was recently enacted in the Children's Code Act, it clearly stipulates, it clearly goes against the issue of marrying off a child who is below the age of 18 years old.
Counsel, would you say that the marriage that was between the appellant and his minor wife was a valid marriage?
My lord, if we look at section 33 of the Marriage Act, it clearly stipulates that if any person who marries someone below the age of 16 years old, that marriage should be considered as a void marriage. It is for this.
The Marriage Act, does it apply to the sort of marriage that was contracted by the appellant?
Much obliged, my lord. I got this point because even the appellants, they quoted Article 34 of the Marriage Act, stipulating that both customary laws and our own customary laws and written laws should apply in Zambia. But I would also like to bring to the attention that to the attention of the court that even the same marriage acts that the appellants were putting their reliance on also stipulates under section 33 subsection 1 that a person who is married off at the age of 16 years old and below, that marriage should be considered as a void marriage, my lord.
It's the appellant's submission that this was a customary marriage. And according to the record of proceedings, it shows that it was a customary marriage. So therefore, the argument that the Marriage Act applies, section 33 applies, it is the argument that falls away because it's a customary marriage. So the Marriage Act does not apply. So under customary law, would you say that this marriage was a valid marriage?
Much obliged, my lord. Under customary law, this marriage was valid.
And it is their further submission that according to the case of our versus Timbers, and the Surrender versus the people, where a person has found knowledge of his own wife, it does not amount to defilement. What is the submission on that?
Much obliged.
They have cited the case.
Okay, much obliged, my lord. In answering that question, I said that under customary law, the marriage was valid. It is, however, our submission upon this honorable court that despite customary law recognizing such kind of practices, before they are actually applied in our own Zambian jurisdiction, in our own written law, before they are applied in our court system, they must meet some certain conditions, and that is, they must not be repugnant to our own Zambian constitution. And hence, despite it being a valid marriage under customary law, it can also be dismissed in a sense that it is going against our own written laws. For example, section 18 of the Children's Code Act, my lord. And furthermore,
Okay, you brought me to what was supposed to be my next question. You are relying on section 18 of the Children's Code. The Children's Code was enacted in 2022.
much obliged.
Does that act apply retrospectively? Does it apply because when was this marriage contracted? Was it contracted before the Children's Code was enacted or after the Children's Code was enacted?
It applies, my lords.
In what ways?
It applies in a sense that the Children's Code Act was made in accordance to be consistent with what the Constitution is actually stipulating.
There's no
hence,
contention about that. My question is, does it apply retrospectively? Does it apply to things that took place before it was enacted? So, for instance, we know that the Children's Code now does not allow child marriages. But in the event that there was a child marriage that was contracted in, let's say, for argument's sake, in 2020, would we say that the person that contracted a child marriage in 2020 is guilty under the offense provided under section 18 of the Children's Code, which was enacted in 2020?
much obliged, my lord. This particular recent law that was recently introduced should apply in accordance from the date of which it was introduced.
So was this marriage by the appellant contracted before or after the Children's Code?
Much obliged, my lord. From the facts given, it hasn't been stipulated as to when this marriage was contracted.
Thank you very much. Can you proceed?
Yes. With that,
Your time is up, so you can say your closing remarks and your prayer.
Just the concluding remarks. Senior Counsel,
much obliged, my lord. With the points that I've established, I seek you to rest.
May I move, Counsel?
If it may please this honorable court, my name is Benjamin Koma, practicing license 057316, and I am the court counsel of the respondent. May it please this honorable court, it is our humble contention that the honorable court should uphold the lower court's decision, considering the fact that Juma Choma Choma is of an adult legal age, while
Counsel, your colleague has addressed us on the issue of age. Why have you cited section 2 of the gender-based law on the side?
section, I haven't cited any law at
I'm looking at your brief right now.
Yes.
In your brief,
Yes.
You've cited section 2 of the Anti-Gender-Based Violence Act.
Yes.
Why have you cited it?
We're just trying to define what amounts to violence, an act of violence. An act of violence has been said to be any physical, mental, social, or economic abuse, an act of omission, threat that causes death or a direct infliction of mental, physical, or emotional pain.
How relevant is that to your argument?
Just to relate it to the case at hand, looking at the girl, child marriage as a result made the girl to have suffered mental, social, and economic abuse.
So where in the fact you are assuming that
It's from the law, the Anti-Gender-Based Violence Act. When it comes to
we
defining section,
appreciate the provision under section 3. What I'm asking is, where in the fact is it saying that because of the marriage, there was this violence that you're talking about?
much obliged, my lord. Coming to a child marriage, according to the marriage, to the Children's Code Act, section 18, subsection 2, it says a child shall not be subject to child marriage. So, coming to this provision that is beforehand, this provision is married to the fact that this child was involved, engaged, in other words, into a child marriage, and as a result, suffered the what is provided in the section,
The section,
the defined section.
section 18 of the Children's Code provides for
A child,
what a child would suffer if they were engaged in a child marriage.
no, my lord. The act states it is contrary to child marriage, and as a result, the child suffered mental, social, and physical abuse.
How do you know?
I am relying on what is provided, the law, my lord.
What law? There's a law that you've cited only provides that a child shall not be subject to child marriage, and the facts before this honorable court do not actually state as to what injury your client might have been subjected to. So how do you know the type of injury that your client was subjected to or might have suffered?
Counsel did not address himself to that, my lord.
Go to your paragraph 1. It says, paragraph 2 and 1, partially that is, paragraph 2 and 1 of the records of proceedings, section 8 of the Children's Code Act provide that a person shall not subject a child married, and I believe that's supposed to be a child married. Similarly, in Article 61(4)(m) of the Bill of Rights,
Just a minute, my lord.
provides that a
Paragraph.
child has one. On your argument. On your argument.
Yes.
On the second ground. You've cited Article 61(4)(m) of the Bill of Rights. What's that now? Or we have a different document?
It is the one, my lord, much obliged. It's a record.
Where is Article 61(4) on the Bill of Rights? How many provisions are under the Bill of Rights?
My lord, just to direct this court to what was meant by this provision, I agree that there were some irregularities based on the Bill of Rights, but it was supposed to be section or Article 61 of the Constitution.
It's the one that provides that the child should not be subjected to the child has the right not to marry or to be forced to marry.
No, my lord.
That's what is stated in your brief.
Do you have the Constitution with you, Council?
I don't.
Can you read Article 61?
It reads, legislative authority. The legislative authority of the Republic derives from people of Zambia and shall be exercised in a manner that protects this Constitution and promotes the democratic governance of the Republic.
So that's the power of Parliament to make laws. It comes from us, the people. How is it relevant to the case that we're...
My lord, I agree to say there are some irregularities in drafting the brief. I seek leave to proceed.
Is this provision from Bill 10? Is a similar provision under Bill 10? Is it from Bill 10?
Yes, my lord.
That bill didn't pass.
My lords, relying on paragraph 3 of the records of proceedings, it is imperative for us to know what amounts to the offense of defilement. Defilement, according to section 138, subsection 1 of the Penal Code, has been defined in a manner as such. Any person who will knowingly and carnally knows a girl below the age of 16 years old shall be guilty of a felony liable to imprisonment for life. My lords, the only defense that subsists with regards to that provision is where it shall be made to appear before the court, hearing the matter, that the person so charged with the offense was caused to believe and had reasonably believed that the person was of the age of 16 or above. But going by paragraph 1 of the records of proceedings, Juma Choma here referred to as the appellant had known for a fact that the girl was below the age of 16 years. In supplementing to this argument, it is imperative for us to understand what ought to be done in such cases. Going by the case of, I simply to have a look at my brief. Going by the case of Piri Machaka versus the people and Gift Mulonda versus the people, it was held, the court directed itself that it is imperative where defilement cases are involved to look at the age of the victim.
So,
my lords,
before you proceed with your argument, you said age is very important, right?
Yes, my lord.
Do you agree with the appellant that there was a marriage at this point?
That there was a marriage, I do not agree, my lord.
Okay. And the customary law, was there dowry that was paid? According to the factor case, was there a lobola that was paid?
It is not provided for, my lords, but coming to the celebration, the type of celebration, it entails that there was lobola, because for any customary marriage to be regarded as a marriage, there is need for lobola to be paid.
You've now just shot yourself in the foot. There was lobola that was paid, it was sponsored from the parents, right?
Yes, my lord.
So those are indicators that there was a marriage, right?
Under customary law.
Yes, under customary law.
Yes,
It is customary law.
Yes, ma'am.
So if there was a married marriage, don't you think there was a right that was claimed by the appellant under conjugal right to actually remain his marriage? Because he contracted the marriage validly. He paid for everything was followed. Thus, he gained the right to have conjugal exercise over his wife. So if that is the case, why is still citing it as defilement?
Much obliged, my lord. My lord, as the submissions made by my co-counsel to say that for a marriage to be valid under customary law, it should not be repugnant to the laws of natural justice provided for by Article 7 of Article 7 subsection D of the Constitution, and as provided for the case of Cavendish versus Jairus, that the marriage ought not to be repugnant to the laws of natural justice.
Citing marriage and citing provisions that are talking about customary law, that's very different. Here, a marriage is contracted. What are the consequences of the marriage? You gain a right of consortium, right? You now the claim to conjugal exercise over the husband, over the wife. That was done. The marriage was contracted. Those rights were attained and exercised. Now, if those rights were exercised, why are you still claiming that there was defilement, despite the age?
On my co-counsel is kindly asking the court to rephrase the question.
Question is this: the consequences of a marriage is that you gain conjugal rights, your rights to have sexual intercourse with your partner. We have rightly established that there were indicators that the marriage was rightly contracted under customary law. There was a lobola, there was parents' consent, and the rites of passage were followed. That is an indicator that there was a marriage. Because of the existence of that marriage, the appellant gained conjugal rights over the wife. He had the rights to exercise his rights, which he did rightfully. Now, why are you still claiming that it was a violation of criminal law, that it amounted to defilement because of the age and the like, when this particular individual rightly married the victim in this case?
Much obliged, my lord. Coming to your question, as provided for by Article 1 of the Constitution of Zambia Act of 2016, it provides that the Constitution is the supreme law of the land. And any law.
Take judicial notice that the supreme law of the land is the Constitution. What is your argument?
Relying on Section 33, subsection 1 of the Marriage Act.
That act does not apply. Marriage is customary. What is your argument?
The argument is that the girl was below the age of 14 years.
And the requirement of age under that act that you've cited is in relation to a civil marriage, not a customary law marriage. What is your argument?
Counsel did not address himself to that matter.
Proceed with your argument.
My lords, my lords, Juma Choma Choma here in referred as the appellant was of an adult legal age, while Kachingwe Kalando is below the adult legal age, and relying on appointing the court to paragraph 3 of the records of proceeding, the consummation that is provided for resulted into the offense of defilement as provided for by section 138, subsection 1 of the Penal Code. With those submissions, I seek leave to proceed to our prayer.
You may proceed, Counsel.
My lords, having demonstrated that the customary marriage was repugnant to the laws of natural justice, and Juma Choma Choma here in referred as the appellant was of an adult legal age and committed the offense of defilement by consummating with a girl below the age of 16 years, it is our humble prayer that this honorable court should uphold the lower court decision and dismiss the appellant's claim. My lord.
Okay, thank no submissions, Moot staff, and we've been in that position before, and this one is never failed. I have personal experience. So there's no improvement with the quality of the briefs and the oral submissions. Like for most of you, there's point where you have a good argument, but you don't substantiate. Like for instance, they brought an issue of international law. There's good case law on how you can maneuver international law, or the distance, or how you can respond to the it's a very good argument. I trust everybody, if you have done international law and you've done sources of international law, I think you've come to a possibility and you can get good arguments from there. So, yes, we have just always say this and that, but at least try to bring out your point. You argue international law, like on what basis are you going to rely on it? You just say, because of this treaty or the EDHR.